This is Mark Simon, and thank you for joining me in Counselor's Corner. The question today is, will I have an income tax liability should I do a short sale on my primary residence? As of this video on January 22nd, 2014, unfortunately the answer to that question is more than likely going to be yes. In other words, anyone considering a short sale at this time needs to be aware of potential tax consequences that may result. During 2007, President Bush signed into law the Mortgage Forgiveness Debt Relief Act. The law pertained to mortgage and other debt that could be discharged for the calendar years 2007 through 2009. This law was subsequently extended by various congressional enactments until December 31, 2013, and thus no longer is in effect. Unless it is hereafter renewed and hopefully made retroactive to January 1, 2014, unless you meet very specific requirements, the law may no longer provide you with any tax benefit. In a short sale, your lender agrees to accept an amount less than the total amount due on your loan. Any amount that is not required to be repaid may, or may not, be agreed to be forgiven by your lender. However, forgiven debt may still be considered to be income by the IRS. Thus, should you, for example, get your lender to forgive all or part of what you may actually owe, the IRS may still expect you to report the forgiven amount and pay income tax on it. You therefore may have to pay income tax on money you never actually received. A short sale, where you are able to obtain a release from any possible deficiency, the shortfall, is a great thing. However, unless the Mortgage Forgiveness Debt Relief Act is reinstated, or you satisfy certain exceptions or exemptions, watch out for potential tax liability. This is especially the case where you may not be able to discharge such tax obligations should you ultimately have to file bankruptcy. This is Mark Simon, and again, thank you for joining me on Counselor's Corner.